any opinions expected till Monday. But I want to start with Espinoza versus Montana. John Eastman, the application of the Montana's Constitution's no aid provision, a Little Blaine Amendment, struck down by the court. How important a decision was this 5-4 opinion written by Chief Justice Roberts?
Well, I think it's an extremely important decision, and it's been long in coming. The Chief Justice had an opportunity to tackle these overtly anti-Catholic biased state constitutional amendments that were all put in place in the latter part of the 19th century, and back in Locke versus Davie, and he didn't. He kind of punted then, but we now have, a pretty good indication that those amendments by themselves are unconstitutional. He didn't quite go that far, but he said the application of it in this case is unconstitutional. And this case was the state providing a tax subsidy to donations made to nonprofits that supported private schools. And it was available to anybody in the state unless the private school you wanted to use the monies at happened to be religious. And that overt discrimination against the religion is what the court held is not permissible. And if the state constitutional Blaine Amendment required that result, then the Blaine Amendment was the problem.
Erwin Chemerinsky, I spent a lot of time yesterday reading the Alito concurrence, the Gorsuch concurrence, the Thomas concurrence, and the Chief Justice's main opinion. I didn't spend much time on the dissents. What do you think about the case?
Well, I think the dissent was right. What John omits from his description is that the Montana Supreme Court found that the Montana law violated the Montana Constitution and invalidated it. So Montana was not discriminating against religious schools. It was giving no aid to any school. And I think by any definition of federalism, if a state Supreme Court strikes down a state program, it doesn't exist. It's also, I think, interesting that John and conservatives who usually say, just focus on the text of the provision, are now saying, because the intent behind it was impermissible, the provision is unconstitutional. I think states can have a variety of reasons for prohibiting direct or indirect aid to religion. New Jersey had a provision saying exactly this long before the U.S. Constitution was written, or there was such a thing as a Blaine Amendment. I think James Madison was right. It's unconscionable to tax people to support the religion of others.
John, your response.
Well, that's not what's going on here. Religions are entitled to the same support of neutral programs that everybody else is. Madison never said otherwise. And to read the many Blaine amendments is, as Erwin has just suggested they should be read, as not allowing any taxpayer dollars to go to anything that supports religion would mean that taxpayer dollars to the police department or the fire department, the taxpayer dollars paid by those religious folks can't go to provide them the same kind of governmental benefits that everybody else pays into the tax system to get. That's what's at issue here. And the Blaine Amendment, quite apart from the intent of the drafters, which was blatant discrimination, is itself discriminatory on its own face, even if you don't look to the underlying intent.
Now, Erwin, I want to pose to you my theory of what the Chief Justice is up to. Earlier in the week in June Medical, he disappointed John and many conservatives, and I probably would have joined the dissent as well, in upholding a Louisiana law that required admitting privileges for those performing abortions, saying, in effect, look, we just decided this 5 years ago. We're not going to change our mind in 5 years. That's not stare decisis. I think that was a prelude to this, and I think if the court were to change in the liberal direction, that they would be at least influenced by June Medical not to overturn Espinoza versus Montana. What do you think of my reading of the Chief Justice's ordering of his opinions?
I don't think so. I think there are plenty of times when Chief Justice Roberts has joined the conservative justices in overruling precedent. Last year, I argued a case in the Supreme Court on sovereign immunity, Franchise Tax Board versus Hyatt. The court overruled a 40-year-old precedent. There was an important takings case last year, Nick, where they overruled a long-standing precedent. Of course, 2 years ago in Janus, they overruled an important case in terms of the non-union members.
But, Erwin, can I ask you a quick question? You just
Sure.
said the key thing. Long-standing precedent. He explained in Citizens United, if something doesn't settle down after 30 years, we've got to fix it. I think what he said this week is, that was just 5 years ago. We haven't seen the kind of unsettling, and no one brought Casey before me. So I think you gave me the critical distinction Longstanding precedents that do not settle controversies are poorly decided and subject to review. Short-lived controversies, don't bring them to me. Erwin?
It's a strange principle of stare decisis because it says that the longer a precedent has been there and the more people have relied on it, the more willing the court's going to be to overrule it. The reality is, if there are 5 votes to overrule Espinoza in 2 years, they'll overrule Espinoza. If there's not 5 votes, they won't. But I think what you and John are missing about this case is prior to 2017, never once in American history did the Supreme Court say the Constitution required the government to give aid to parochial schools. I think the bottom line from Chief Justice Roberts' opinion is whenever the government gives aid to secular private schools, it must give that aid to religious schools. And I think that ignores the Establishment Clause of the First Amendment.
John, I want to read to you something Justice Alito wrote that I think answers Erwin's objection. Many parents of many different faiths still believe that their local schools inculcate a worldview that is antithetical to what they teach at home. That's the difference between now and then. Many public schools have gone off the deep end, and many people are turning to private schools, some of them religious, to save their children's worldview. And hostility towards those schools is unconstitutional.
Well, I think that's right. But look, this is not a new phenomena. The reason the many Blaine amendments were put into place is because the Catholic schools were competing with the what quote unquote public schools, which were overtly Protestant.
Yes.
So the notion that the public schools in the 1840s were kind of these neutral, a-religious places is just not true. So the issue has been with us for a very long time. And look, let me go back to the question you asked Erwin a minute ago about Chief Justice Roberts.
I knew you would.
I think that I tend to think you might be right about what his thinking is. I just find the thinking unbelievably naive because I think there's no question that if Kagan and Breyer and Ginsburg and Sotomayor pick up one other vote on overruling anything, they're going to do that, and they're not going to hesitate one iota because John Roberts went south on us on June Medical.
But you understand what I'm saying? He's trying to build a wall against rapid reversal of precedent as opposed to okaying the reversal of longstanding error.
Maybe, but he's got his finger in a dike that will be completely meaningless because there is no way that the 4 liberals on the court don't vote to overrule precedent in a heartbeat, no matter what he has done in June Medical.
But Erwin, you know the Chief Justice and Citizens United laid out the criteria for invoking stare decisis and setting it aside. And that criteria is if the court's original ruling has failed to secure a consensus over a long period of time. For example, I do not believe Obergefell will ever be overturned, no matter how many Republicans you put on the court, because society has reached a consensus. And what the chief was saying in Citizens United was the court does not disturb consensus that follows its early decisions, but if a consensus has not arrived, like in Janus, we will correct our errors. Isn't that what he's saying?
It's a strange constitutional principle that says that the meaning of a constitutional provision depends on popular consensus. I don't think that's how constitutional law should function. And that may be John Roberts' view, but I don't think it's what other justices are going to follow.
John Eastman?
And if that were true, then he would be ruling the other way in June Medical, because there has been no consensus on the question of abortions for the 47 years since it's been in place.
But John, he said Casey wasn't in front of him. He said that. And I want to get your opinion on what that means and Erwin's opinion on what that means.
Well, okay, so at least distinguish the factual differences between the Texas case in Whole Women's Health versus Hellerstedt and the Louisiana case. One of the critical factors that got Kennedy's vote in Hellerstedt was the fact that Texas is so big that there were hundreds and hundreds and hundreds of miles between clinics, that if any one clinic closed down, people would not have the same kind of access to abortion care that they might otherwise have. That was not true in June Medical. Louisiana is vastly different on that score than Texas. That was more than ample ground enough to distinguish the case without overruling the recently adopted precedent. And yet he didn't go there. So this is why people are so angry with Chief Justice Roberts at the moment.
Erwin, let me ask Erwin.
I think the thing that explains it better is judicial supremacy. We ruled, and you ought to settle down and listen to what we've said. And that's not the role of the court ever.
Okay, we disagree, but I want to get Erwin's reaction to the Chief Justice noting that Casey wasn't before him.
Well, obviously, what he's doing is leaving open the question of whether or not he's willing to vote to overrule Casey and therefore Roe versus Wade. And that's what led to the New York Times editorial yesterday about it. It seems very strange to me, though, to say that Casey, which was 1992, or Roe, that was 1973, that millions of people have relied upon, would be more vulnerable than a 4-year-old precedent that has had very little impact. It's just a strange theory of stare decisis.
No, it's an
I've
absolutely,
never seen before.
it's a common sense stare decisis. Oh, well, we could go this forever. I want to give a last word to you both on what you expect next week. It's got to be 30 seconds. John Eastman, will the term end on Monday and with a bang or with a whimper?
Well, the big case that's still sitting out there is Our Lady of Guadalupe, which deals with how broadly the ministerial exception to various federal laws is going to be applied. Who knows what's going to happen, but I think that will be a big case, and therefore the term will end with a bang. I don't think we're going to get any retirements. I know I see speculation that Sam Alito's going to step down. I saw another article that there's going to be a double retirement with Alito and Thomas. I don't suspect either of those is going to be the case.
I told Robert Costa yesterday, I've heard the Alito gossip, and I don't know Justice Alito. I doubt Justice Thomas is going to quit very much. But if he did, and he wrote the opinion on Our Lady of Guadalupe, that would be a mic drop time to walk off. Erwin, what do you expect on Monday?
I think there are going to be the cases coming down with regard to the subpoena of President Trump's financial institutions, really cases about the rule of law. But are we sure that all cases are coming Monday? Have they said that?
No, that's what SCOTUS blog is speculating because of the length of the term already.
Yeah, I'd be surprised. I think there's still too many cases to come down on one day. I know they don't usually go beyond June 30th. They also don't usually have oral arguments in May either.
Oh, good point. Good point. We can distinguish this year on the basis of the virus. Dean Erwin Chemerinsky, Dean Emeritus John Eastman, thank you both.